Cloud. Okay, great. So it's noon. We'll go ahead and get started. I'm Michelle Morris with Consolidated Planning Group. I'm going to start things off by going over kind of the rules of the road for today. I don't know if you've seen any of our webinars in the past, but when we're in webinar mode, we cannot hear or see the audience, but we know you're out there and we see the number of participants going up and up and up. So please put your any questions that you might have in the chat box. I'm going to keep an eye on that for the presenter, Melissa Donovan, while she's speaking, and I'll let her know when we have questions. This webinar is being recorded, and we will send a link to the recording out to you later on today, as well as a copy of the slides. So if there's anything that we go over that's clickable, you'll be able to click those slides later on today. If you're listening on our podcast, which is, new and exciting, we're doing a podcast now, you can get the slides by emailing contact@cpgcares.net. That's cpgcares.net. All right, so we should be here for about an hour. And Melissa, if you want to go over to the next slide, today we're going to be talking about, do I need guardianship? And here at Consolidated Planning Group, we are a holistic financial planning firm. We focus mainly on families who have special needs loved ones. The reason is, we've been a financial planning firm for about 30 years. And that was before Allison, the owner of the company, realized that her two daughters had disabilities. So once she figured that out and she realized how complicated the world of benefits and SSI and waiver programs and all of that, how complicated that all was, when she realized that, we kind of turned our focus so that we could be out here educating families and advocating for families, so it won't be as rough for you as what she had it. We are members of the Special Needs Planning Academy, $1 Million Roundtable, Top of the Table, which just means that a lot of families trust us to do business with them. We're fully licensed when it comes to life insurance and securities, and we're nationally certified as Social Security advisors. We are located just outside of Houston, but we serve families all across Texas and all across the United States, as a matter of fact. On the next slide, I want to talk a little bit about what families come to us for, special needs planning, and of course, financial planning. So across the United States, there are over 263,000 financial advisors, according to the Bureau of Labor Statistics. Now, less than 250 of those focus on special needs planning. So that's less than 0.1% of financial advisors have this knowledge base and this expertise in working with special needs families. People come to us to help with lifetime protection plans, future care cost estimates, transition planning, setting up ABLE accounts, and like I said, the education and the advocacy that we do for families is very, very important to us. It's part of our hearts. It's part of who we are. It's what we live and breathe on a daily basis. Things that we want you to be thinking about, and we do have a couple more slides at the end of Melissa's presentation that will go over some more things, but we want you to develop that future care plan as early as possible, because the earlier you get started, the more impact you can have on your family's future and the more change you can make. We want you to think about what's going to happen after high school. There are educational options and vocational options, residential options. What's going to happen? How long are you going to have your child living with you in your home? And at what point would you like to see them move off to their adulthood? And how is that all going to work? How are you going to pay for that? You want to start touring these residential communities early, because there could be waiting lists, and it might be difficult to find just the right spot for you and what's best for your family. And make careful consideration when you're thinking about just allowing a sibling to step into the role of caregiver. Um, we prefer that you use a third party, because we want the sibling relationship to be something that is supportive and loving, not obligatory or resentful. So that's important to keep in mind. So today I want to thank Natalie for hosting us. I'm going to give her a few minutes to speak, and then Melissa will take over. So Natalie, why don't you tell us a little bit about your group?
Sure, thanks. I don't want to take away Melissa's time, but just really quick, if any of you have not joined us previously in our partnership webinars with CPG Cares, I am the social services director out here at High Point Village. In High Point Village, we're out here in Lubbock, Texas. We're a 501c3 nonprofit, and we serve individuals with IDD. We do that through daily enrichment programs for adults 18 and over. That's like a Monday through Thursday program. We have afternoon enrichment for ages 8 and up. We have summer camps for ages 8 and up. And then we have music and speech therapy. And we're hoping to maybe eventually branch out to other therapies. And that's for all ages. And so we really serve the community as holistically as we can. And then I come in the social services, so I help connect people with resources, whether they even darken the doors of High Point or not. And we try to do reaching out to the community with respite care, respite nights, and stuff like that. So, and then we do have a vision. You mentioned residential. We do have a vision. It's always been part of our mission statement to have a residential facility out here. That, of course, takes a lot of time and planning and money. So we're taking steps in that to that end. But and I just so appreciate partnering with CPG. This is our third one, and we've got one more coming up on May 19th, which is going to be the Special Needs Planning, the Special Needs Trust. So join us again if you want to be with High Point Village. But thank you guys so much. Melissa, off to you.
Well, thank you both. So again, thank y'all for joining us today. My name is Melissa Donovan. I'm a certified elder law attorney and a partner here at Texas Trust Law. We're actually located in Austin, but we help people really across the state. And I always like to kind of say, because certified elder law attorney tends to make it sound like I only work with old people. And that's not really what that means. Certified elder law attorneys, kind of like Michelle was saying, they are few and far between in the entire state of Texas. Probably a lot of you would say we have too many attorneys. There are over 100,000 attorneys just in the state of Texas. There's only 30 of us who are certified in this area of law. So it really means that our specialty is special needs planning, whether that's younger crowds or older crowds. We deal with a heightened level of responsibility in dealing with Medicaid, Social Security, and things of that nature. So today's presentation, we are here to talk about guardianship. And this is something I think is really important, because I have met with clients on both sides of the spectrum. Some who think that they have to have guardianship because they've been told forever and ever that they need to have guardian and everybody needs to have guardianship, and they don't. And others who don't think they need it at all or don't want it, but it's kind of the point of what they need to do. So we're going to walk through when you might need guardianship, when you might not need guardianship, and kind of the different levels that guardianship entails. And one thing I will say as we go through, I do like to take your questions as we go through. If you do have questions as we go through the presentation, I'm going to ask that you try to keep them as general as possible in nature. If you have really personal questions, keep in mind this is a group of many people across the state, so you may want to hold those really personal questions for a private conversation with a professional. So, guardianship. Guardianship, realistically, when we talk about what is guardianship and does someone need guardianship, what guardianship is it essentially is taking the rights away from a certain individual so that someone else can continue to manage and control what is going on in that person's life. Now, that might sound kind of harsh. The easier way when dealing with younger children, and the way I like to explain it to my clients when we do have to get guardianship, is for your children who may not be able to turn 18 and move on with their life in the way that other 18-year-old children will. I don't think any of us expect that any 18-year-old graduates from high school and suddenly is magically able to do every single thing that a 35-year-old can do. Yes, legally they are adult. I don't think any of us would consider them a full-fledged able to live on their own without any assistance or help. But with guardianship, what we are saying is that this person needs help, and you need to continue to be able to be the same parent that you were when they were 17 years old and 364 days when they turn 18. So it's allowing you as a parent, usually, sometimes there are different scenarios and someone else has to step in as guardian, but it's usually about making sure that you can maintain your ability to help your kids as they get older, who don't have the ability to maintain and manage things on their own. So when we're talking about special needs, this is a general kind of picture for you of if I have a child who has whatever condition it may be, whether I have a child with autism, Down syndrome, cerebral palsy, whatever the situation might be, this is your toolkit. So there's a lot of things that you need to think about over time. And I know it can get to be really overwhelming, which is why, we do say here, and I do fully believe it is a team sport. And in that whole saying that it takes a village, it really does take a village when you're dealing with these scenarios, because it's a lot on one person and it can get to be overwhelming. So there's a lot to think about. We need to think about Medicaid. We need to think about Social Security. And when a child turns 18, there's a lot to think about in that moment, because a lot of the things that your child may not have been having access to while they were a minor, all of a sudden that is open to them. So for example, Medicaid and SSI, a lot of children in families that they would not qualify for those benefits as a minor because they look at you as parents. The minute they turn 18, going back to what I said, they're a legal adult. So the government's not going to look at them as being a dependent on you naturally. So you get to have these benefits that are opened up to them. But at the same time, there are things that you need to consider so that you can continue to be able to help them. Because even myself, I remember being a freshman in college, and the first time I tried to have my mom make a doctor's appointment for me and I had to do it myself, I wasn't all too happy about it. So imagine if your child didn't understand how to even do that for themselves. You need to be able to continue to do those things for them. Those are the types of things that you can continue on with, but there may be some options depending upon the situation with your child that we're going to go through today. So with guardianship, like I said, it's a high level of scrutiny, and you're involving necessarily the court in your life and your child's life moving forward. So there are different mechanisms that can be used depending upon the level of understanding and capacity that your specific child has. So a really popular option right now that's become more prevalent are things called supported decision-making agreements. These are things that go along with things like financial and medical powers of attorney. There are some things that any child should have, and I guess I shouldn't even call them a child technically. When they turn 18, any young adult should have in place simple things like financial powers of attorney and medical powers of attorney and HIPAA authorizations, so that someone can help them in the worst case scenario. If I have an 18-year-old daughter who's going off to college, I'm going to want my daughter to have a power of attorney in place so that when she goes off to college, if she's in an accident or she can't do something, myself or my husband or her aunt or uncle, whoever it might be that she wants, someone is there to help them. If you have a child who is dealing with a situation with a diagnosis, but their capacity is at a level where they can basically understand and sign those documents, you may not need to go about guardianship. But if the situation is a little bit more severe to the point where your child really doesn't understand, and it is a danger for that individual to be able to just kind of go out in the world and be making their own decisions on their own, that's when we need to start considering guardianship as an option. So we go through these different things that we're going to consider. What is my child's scenario? What is the diagnosis that we have? Do we have a diagnosis where maybe it's a severe level of autism or Down syndrome or cerebral palsy, where they're never going to be able to handle life on their own, and they're always going to need someone to be there, look out for them and make their decisions? So that gets into, is it a temporary scenario? Is it a permanent scenario? Now, one thing I always like to point this out, because we hear so much about permanent guardianship and temporary guardianship. There is really no such thing as a permanent guardianship, because every guardianship has to be renewed annually. And if that guardianship is no longer necessary 3, 4, 5 years down the line in the future, you're going to be letting the court know that, and you're going to have that opportunity to say, you know what, I don't need this anymore. My child can handle things on their own. So we're going to take a step back. Okay. So that's why I really don't like that we refer to guardianships as being permanent, because I think it scares a lot of people into thinking that it is truly permanent. It's not. It's renewable annually. So when we talk about what types of guardianship are there, so with temporary guardianship, I'm going to jump to the bottom real quick here first, because temporary guardianship is meant to be there for emergency scenarios. So where you see temporary guardianships happen a lot is more so on the elder side of things. When you have situations where mom or dad get into a really serious accident, there's something that needs to occur and there's no powers of attorney, there's no one that can make that call. That's where you get into this emergency kind of temporary guardianship, where it's something that's there to last for a minimal period of time to get these decisions made. And then we don't need that guardianship anymore. We're not going to talk a whole lot about that today, because that's not typically what we're dealing with when we have children with special needs. We are dealing with a permanent, remember, take that with a grain of salt, a permanent guardianship. And we're dealing with either a guardian of the person or a guardian of the estate, or a combination of the two. Now, I always tell people right up front, if you are having a minor child who is about to turn 18 and you're looking at guardianship, as your child is aging, so when they're teenagers and they're 14, 15, 16, getting into 16, 17 years old, you really want to do everything you can to keep any money out of your child's name for two reasons. One, when your child turns 18 and you're going to be looking at things like SSI, you need to make sure that he or she does not have any assets in their name, to make sure that we have qualification for those benefits. But from a guardianship perspective, if you can avoid having to get a guardianship of the estate over someone, you want to. We always want to push for, if we need guardianship at all, we want to limit it to a guardian of the person, because that's going to keep your life easier and it's going to make your beneficiary, I don't like to use the term that the state technically uses and the law uses is ward. So you'll hear me as we go through the presentation today. I'm going to just talk about your child. Okay. But if you have a guardianship of the person, you're minimizing the court interaction and you're minimizing the difficulty in what has to be done. With guardian of the estate, you are going to be much more intimately intertwined with the court, and we want to try to avoid that as much as we can. So full guardianship versus partial guardianship. So there are a number of things that when you get guardianship for your child, you're taking over their responsibilities and rights on those items. So things like voting. Now, no, you don't go vote for your child in the public election. It's just that your child doesn't get to vote. Your child may not be able to have a license. They don't get to make the decisions on who they marry or where they live or anything like that. So in some scenarios, there are situations where a child who now is going to have their parent or someone act as guardian, they might still have a limited capacity to be able to do one or some of these things. So that's always going to be personal to the situation in front of you and your family. Generally speaking, if you are getting a guardianship of the person over your child, most of these things are going to be included in that guardianship. And like I said earlier, as time evolves, and the situation changes, your child as they get older might be able to come back to doing one or more of these things over time. So you can kind of baby step it as you need to. There are always going to be those scenarios too, though, where it's going to stay the same for a long term. But voting, marriage, licenses, decisions regarding education, work, all of those things are things that a guardianship is going to take those decision-making abilities and place them in the hands of parent, sibling, whoever it will be. And we'll come back to sibling in the future of this presentation, because for the most part, I do agree with Michelle wholly. And when it comes to guardianship, when it comes to special needs trust, when it comes to anything, when you have siblings, typically, especially when they're younger, you do not want to have siblings having to do these things for one another, because you want them to be siblings. It's kind of like when I'm talking to clients on estate planning, and every now and then I'll get those questions from my clients who have minor children and they're struggling with, well, who are we going to name as guardian if something happens to us? And they're not sure if they want to name grandma and grandpa. It's like, I will tell those people, let grandma and grandpa be grandma and grandpa. They don't need to be mom and dad. Let sibling be sibling. They don't necessarily need to be mom and dad until they actively make that choice that they want to do it. And you will have those people. I have a wonderful, like absolutely love her. I have the best paralegal who helps me with my guardianships, and she's been guardian for her sister for over 35 years. And she would fight you to the death if you tried to take that guardianship away from him. So there are certainly siblings like that, but you want to make sure that your kids are older and they are making that decision for themselves. You don't want to force them into that. So guardian of the person, what does this mean? So this is always a big question because no one really knows going into these things, what does this look like? What do I have to do? If I have to get guardianship, does this mean I'm the guardian? We have clients all the time. We do what are called declarations of guardian when we're doing estate planning, and there will be a misconception. Well, this piece of paper says that I'm the guardian if something happens. So I'm just the guardian, right? No. So there's always going to be a court involved. There's a process. But what the guardian of the person does, and that's what we want to try to limit things to, is they handle the health and welfare, essentially. So like I said, we want to try to keep assets out. Generally speaking, if there's less than $2,000 in your child's name when they turn 18, even if there's some money, you don't need to get a guardian of the estate if there's a minimal amount of money. You need guardian of the person so that you can, like I said, continue to be their parent, okay? So there are certain criteria that you have to meet in order to be guardian. It's relatively simple and straightforward. Essentially, you can't be a felon. Okay, if you are a decent human being and you don't have a lawsuit against the person that you're trying to get guardianship over, and you have their best interest at heart, you are generally going to be appointed. If you're the parent, you are generally going to be appointed as the guardian. Now, the one thing I will say that is really important to keep in mind is that when it comes to a guardian of the person, you can have a co-guardianship over your child, but only if mom and dad are married. So if you have a situation where there's been a divorce, you have to have these conversations early on so that you can make sure that things are going to flow easily. Because if mom and dad are divorced, and let's say mom wants to be the guardian, but dad's not on the same page, that's where you end up in contest issues. So you want to try to get things on the same page to make sure that we're going to have the appropriate guardian in place there. But that guardian is going to have the right to, the way they put it is physical possession. So I get this question all the time when my clients are talking about, well, who's going to be guardian if something happens to me? And if it is going to be my other child, do they have to have my special needs child live with them and so on and so forth? That doesn't mean that they have to live in the same home. It means that you have control over where that person is going to choose to live. So for example, maybe they're going to be living in a group home scenario, or maybe they are able to live on their own with assistance. It doesn't necessarily mean they have to be under the same roof. It just means that you are controlling the physical location of that individual. You do have duties and obligations. If you are guardian, just like a parent has obligations to their minor child, you have an obligation to make sure that that person is taken care of to the best of your ability and that they are safe and healthy. Now with the court, because I mentioned this earlier, we want to avoid guardian of the estate because we are much more intimately intertwined with the court. With a guardian of the person, once you have that guardianship in place, every year you're going to have to report to the court what has changed. How are things going? Most courts utilize the same reporting form. It's, about 8 pages long. And I know that might sound long, but it's a relatively straightforward thing that you will fill out year to year saying, okay, have we moved? Is my child in a new location? How is his health or her health doing? Has the situation with the condition that we have guardianship due to, has it improved? Has it gotten worse? Has it basically stayed the same? So it's just you're letting the court know year to year, this is how things are going. And that's why I say, eventually there might come a time where you fill out that report and go, everything's going great. My child has improved exponentially. And we don't need this anymore. And then you will stop the guardianship at that point in time. With guardian of the estate, this is why I say, and you'll see here that you have a lot more duties and responsibilities, and it's harder to do things over time, okay? Because when you are dealing with the financial side of things, you are going to have to get essentially permission from the court for how you spend that money over time. So depending on the circumstances, that could involve having to go to the court on a regular basis for constant okaying of what you want to do. many times it's just a matter of kind of the way I like to explain it, it's like getting a budget in place with the court, and they'll say, okay, you can do this and you're fine so long as you're within there. But the one thing that I also like to point out with guardianship, bond. Okay. So if you've done any estate planning, most people, if you've done a will and you look at your will, there's a provision in your will that says my executor can serve without bond. You cannot do that with guardianship. The rules are the rules, and that you will be required to post a bond regardless of what any purported document might pretend to say. Okay. Now with a guardian of the person, it's going to depend on the county that you are within. So the examples I like to give, because this can broadly range. So here in Travis County, where I mostly practice, Judge Herman, we require a $13,000 bond for any guardian, parent, anyone else. There is no exception to that rule in this court. So that being said, that does not mean that you take $13,000 and post it with the court. It is a bond, it's an insurance policy. So right now, it's about $300, I believe, for a lifetime $13,000 bond. So you basically pay money to insurance company, and that is your protection to the court, where you're able to say, okay, there's this money here. So if I mess something up, everyone is kind of protected. That's minimal. Now, really minimal, if you go out to, Fayette County, Bastrop County, even Williamson County, you'll see differences in courts and how they do bonds. So, Williamson County, typically, if it's a parent, will do a $100 cash bond. And I've had courts where they don't require any bond at all. So it really is very specific to the location that you're in, which is why it's usually a good idea if you're in different counties, or at least very different areas, to seek out the advice of an attorney that's really intimately familiar with that area. Because I might know this area, Travis County, Williamson County, all around me. But if I'm going to El Paso, I'm not going to have any familiarity with that court. So it's really important that you have familiarity with an attorney in your area that can help you with those things. But beyond that, if you're dealing with a guardian of the estate, you have a much higher level of bond that is going to have to be posted. And depending upon how much money, it could be up in the thousands or hundreds of thousands. Now, typically, that's not going to be the scenario if you're dealing with a child turning 18, but this is where you get into when you have parents and you're dealing with guardianship for parents who might have dementia or Alzheimer's, and you start getting into these very heavy bonds. And sometimes people who would otherwise be qualified for guardian, because of the financial side of things, they won't qualify because they won't qualify credit-wise or whatnot for the bond itself. So it's just things to keep in mind, because there's two different sides of this here when you're dealing with kids and dealing with adults. But again, you want to try to keep any assets out of your child's name as much as possible as they're getting close to 18 years old. So when you're filing for guardianship, the best time to start looking at it, if it is necessary, I always tell my clients, you want to start thinking about this at least 6 months before your child turns 18. It can take several months to get through the process. Now, that being said, most judges are not going to hold any kind of a hearing until at least a week after your child's 18th birthday. They can't hold the hearing before they're 18 because there's no need for a guardianship until they turn 18. So the reason that you start the process a little bit further back in advance is because you want to get all of that legwork done so that you can get that guardianship in place as close to the 18th birthday as possible. That being said, most people, if you have a regular ongoing relationship with schools, therapists, doctors, the people around your child that you're dealing with on a regular basis, most people are going to give you a good amount of grace. And if you run into someone who says, hey, we need proof that you can do these things, in my experience, if you let them know that you're in the process of obtaining guardianship, I have yet to have a client come back to me and say, this person won't work with me at all. Now, if you are dealing with a new person, that's where you run into this issue. So if, let's say, your child has to go to a hospital for something like that, you're not dealing with those people on a regular basis. That's where you want to make sure that these things are in place. But you don't need to have an anxiety attack that this is not in place, right away after your child's 18th birthday. You have a little bit of a grace period with most people that you work with on a regular basis. But the first thing in the process, and it depends on the disability that your child has, is obtaining either an intellectual disability report or a doctor's certification. Okay. And most counties utilize the same forms for these things. The physician certificate is where the doctor is letting us know. So the attorney, it's letting the court know, what is the actual health condition? What is the diagnosis? What is the prognosis? What are the things that your child is capable of doing? So the court's going to require that. So it's going to be either one or the other. If you have a determination of intellectual disability, then that can be used as opposed to a physician's certificate. But many times people don't have those yet. Okay, so if you have a child who's already been on Medicaid, who's already dealt with care organizations, who's already had these reports done, then you can utilize that so long as it's no more than 2 years old. Okay, physician certificates have to be done no sooner than 6 months prior to that 18th birthday. Okay, so that's why I always say, think about that about 6 months in advance. Once you start the process, you have that in place. There's going to be an application to the court, and then the court is going to appoint another attorney because your attorney represents you and you're trying to get guardianship over your child. The attorney that the court is appointing is there to represent your child. Okay, it's called an attorney ad litem. Their job is to represent what they see as the best interest of your child. Now, generally speaking, in clear cases, that ad litem they're not going to really fight you on it. And I tell all of my clients, when we get into a hearing, most people have never been in court before. If you have experience with court, most of us have it from Law and Order. So I tell my clients, and I was a big Jack McCoy fan. And my phrase is, this is not Law and Order and I am not Jack McCoy. No one is here to trick you. When you go into a hearing in this scenario where you're dealing with guardianship of the person, you're generally dealing with the ad litem, the judge and his staff or her staff, and you and your attorneys. And it's pretty collegial. No one's trying to be Perry Mason over here. Everyone is on your side. And most of the time, you're not going to have any contesting issues. If there is a contesting issue, it's because that ad litem doesn't believe that you actually need the guardianship. And maybe there was a situation where we didn't consider lesser restrictive alternatives, which we'll talk about more in a little bit in a second here. But once you have that hearing and the judge goes ahead and approves your guardianship, then you're just going to get to continue being mom and dad. Basically what it is. And so it's a relatively straightforward process. It just takes time to go through. And I've had my quickest guardianships take 2 months to get from beginning to end with really good ad litems that are really on top of things and clients that are really responsive to emails and phone calls and scheduling appointments. My longest guardianship took over 8 months. And it all depends. Now, granted, I always say that was kind of in the thick of things with COVID and people were having to figure out Zoom and all that sort of stuff. But sometimes it can take longer. So the sooner you start the process, the more likely you are to have that situation and have that hearing in place and everything good to go as close to the 18th birthday as possible. So this kind of goes through a list. I'm not going to spend too much time focusing on this. Like I said, so long as the person is not a minor and not, the term is a notoriously bad conduct. So that's where you hear people say, well, you can't be a felon and be a guardian. There are scenarios where people can have like misdemeanor charges and some other things, and that's not going to harm you from being a guardian. But essentially, you can't have a violent history. You can't have any history with the ward that you're trying to get guardianship over. You have to have, you are a fiduciary for that person. You are having to take care of that person and make sure you are always looking out for their best interest. So if we have someone who hasn't proven an ability or has alternatively proven an ability to not behave that way, the court's not going to appoint them as a guardian. So we've talked all about guardianship, and now you all probably want to avoid it. So some of you probably can. So when we're talking about avoiding guardianship, there are some main things that we are looking at. And I kind of brought up some of these earlier. So simple things. Most people are familiar with powers of attorney. So a durable power of attorney is your financial power of attorney. Okay. If I'm incapacitated, if I need someone to help me pay my bills or manage my bank accounts, that's going to be my power of attorney, my financial power of attorney. On the healthcare side, we've got medical powers of attorney, and we've got HIPAA authorizations and medical directives. And some of you are probably going, what does all of this stuff mean? So a medical power of attorney, that's who tells the doctor what to do. And this is the key. If you can't tell the doctor yourself, okay? And I will come back to that because there's a really big point in that distinction. HIPAA authorizations are really important because that's what's going to tell the doctor, I'm okay to share medical information with these people that you've designated here. Now, directives, advanced directives, most people know those as living wills, life support documentation, things of that nature. But coming back to that medical power of attorney, okay, and that key distinction that I just said earlier, your medical power of attorney cannot tell the doctor what to do unless you cannot tell them yourself. This is why supported decision-making agreements became so prevalent in the last few years. So what a supported decision-making agreement is it is a contract essentially. Now, the really good thing about these agreements is kind of twofold. The level of capacity that your child has to have to be able to sign one of these contracts, supported decision-making agreements, is actually relatively low. It's one of the lowest levels of capacity that someone needs. It's really right above testamentary capacity, which is the lowest level of capacity anyone needs. They have to have a basic understanding that they're signing an agreement and saying, I want this person's help. That's what they're saying. The supported decision-making agreement is not there to say you get to override what your child's wishes are. It is saying, I understand as the child that I need help and that I don't understand every single thing about every single thing. If only every 18-year-old would say the exact same thing or 22-year-old. But
You are so right.
But what it is saying is, because I understand that I can't make every decision for myself because I don't have the knowledge base to understand everything that might be put in front of me, I need mom's help, dad's help, whoever that person is. And it is a decision that they are making and an agreement that you are making with your child that you will be there to help them gather all of the information and process that information so that your child can come to a conclusion and a decision with your help. But realistically, it's their decision, okay? So anybody over the age of 18 can do these agreements, okay? Like I said, that level of capacity, because it's technically not defined, it has been deemed to be a very low level of capacity. It is best practice, and this is what I go through with my clients too, that when you're doing these agreements, that your child has the ability to also sign medical and financial powers of attorney. Because the thing with supported decision-making agreements, and like most new things in the law, is when things are still relatively new, it takes a while for third parties to get on board of using them, okay? So you can still run into scenarios where third parties, schools, I don't see it so much with schools, and probably they would be the least likely to do it, but you might run into a hospital, you might run into a scenario where they don't want to follow this. But the supported decision-making agreement does have to be accompanied by a HIPAA authorization. Because the point of the supporting decision-making agreement, it does go beyond medical. It is any decision. So it's work, it's school, it's housing, it's doctors, it's all of those things. It gives you the authority and the permission to gather that information. Okay, so you want to make sure that this is why I say you want to make sure that if you're doing these things, that your child at least has the ability to sign the powers of attorney at the same time. Because while some organization may look at this and say, I'm just not buying it, technically they shouldn't, but we don't even have laws in Texas that they have to accept your power of attorney. So, I don't hold my breath on things too much. But that power of attorney is there as a backup that you can get it. And the HIPAA authorization is really important too, because that's going to be a little bit, it just adds strength behind it. But it can be a really good tool for families who want to try to avoid the guardianship and actually can, because your child does have that even minimal level of capacity to understand and sign these things. It's an important choice. And realistically, these things are out here. Because as much as everybody gets drawn into, the Britney Spears guardianships and all that sort of stuff, courts really don't want to do these things. Okay, I know that might be hard to believe, but I mean, I can speak for, maybe I shouldn't speak for Judge Herman, but I can speak of Judge Herman. He wouldn't want to do a guardianship. No judge I know wants to put a guardianship over someone who doesn't absolutely need it. Because you are taking that person's rights away. And the court is not supposed to be in the business of willy-nilly taking people's rights away. Okay. So the supported decision-making agreements can be an important alternative when combined with some other simple things to avoid that when it's possible to avoid that. So when you're kind of thinking through these things, okay, these are the things that you want to kind of consider. You have a group around you, okay? You want to take in all of the support that you can. You want to talk to your financial advisors. You want to talk to the support groups that you're a part of. You want to talk to your school, your kids' school, doctors, everybody around you. All of those people are there to help guide you in the right direction. Now, I always kind of briefly throw in points because, like I said, I do work with a lot of elderly clients. So think about these things, especially if you're really in that sandwich generation of you're still caring for your kids and now your parents are getting older. Not a bad idea to have these conversations with your parents and make sure they've got good planning in place to make it easier for you if something happens to them. But you want to map out in advance for yourself, just like you do with anything else, what your child's 17th year is going to look like. When we are in 16, 17 years old, are we going to be looking at Social Security? Are we going to be looking at Medicaid? Are we going to be looking at the need for guardianship? And realistically, after that 17th birthday, you're going to really want to focus on getting that information in place and mapping out that plan. If you haven't done it in advance, which, like Michelle said earlier, the earlier you get started on anything, the better the outcome will be. You want to put those plans in place. You want to talk to the people around you about what needs to be done. And there are really great tools out there, for pretty much any situation, for any diagnosis that your child may have. There's some support group, there's CPAT, there's Autism Speaks or whatnot. There's all sorts of groups out there to help you, just go on forums or go on meetings or whatnot. So you can get really good information from them as well. But before your child turns 18, you want to really start thinking about, and the first step I would say is talk to their doctors. They're going to be the ones that have to make the final decision before it goes to court anyway. So you might as well get their opinion up front. What's the prognosis? Before my child turns 18, do we think we need a guardianship? Do we think that they can sign some documentation? Do they have a level of capacity that they can understand what it means to sign a power of attorney, to sign an agreement, letting me help them make decisions? And if they can do that, then you can avoid the guardianship altogether. Okay. Now, if they are able to do that, then it's just about making sure when they turn 18 that your child does execute those documents, the supported decision agreement, powers of attorney, even a very simple will. So God forbid something happens to them, everything is taken and account for. Now, this might be a first. We had no questions throughout this entire presentation
at all. Nope.
And I talk a lot, so.
You've been extremely clear and concise, and you're a good teacher, I guess.
Yeah.
All right. Well, all of Melissa's contact information is there on the slide for you. She has also put it in the chat box. So if you have questions afterwards, you can reach out to her if you want to speak with her personally about the issues that your family is facing. You can reach out to Melissa directly. So there are a couple more slides. Don't run away quite yet. We want to talk a little bit more about things that should be on your radar when it comes to special needs planning. Now, we do webinars anywhere from 1 to 5 times a week, generally around here at Consolidated Planning Group. Hopefully this isn't your first one, but if it is, welcome. We always put them on our YouTube channel after the webinar is finished, and you can always watch them later. I did see a question pop up, so I'll grab that in a second. Things that you want to be thinking about: how to develop that comprehensive care plan for the future, what the cost of care is going to be, not just right now. If your child needs a residential community or full-time care, what is that going to cost in 20 or 30 years when you're gone and you can't do it yourself? We talk about the waiver programs and interest lists and other government benefits like SSI and SSDI, knowing which is which and when you apply and how you apply, how that all works. We help people with that a lot. ABLE accounts, beneficiary designations. It's very important that your child is not listed as a beneficiary on anything. What you need to do is you need to have a special needs trust set up and have that trust listed as a beneficiary. And a special note, if child support is a thing in your life and your child is getting child support beyond age 18 because of their disability, that child support will need to go to a first party special needs trust. Again, start touring those communities early if you want your child to go to a residential community, because they have different audiences, different ways that you can pay for them. Some will take waivers and some are private pay only. And the waiting lists can be long. They have different feels to them. And if you find the right one, you don't want to then find out that you thought your child could move in next month and they're saying, we have a 5-year waiting list. Consider, guardianship. Of course, that's what we've talked about all day today. Reach out to Melissa for help with that. And what your options are beyond high school. Once they are adults and they're transitioning into living life on their own, or at least out of being in school all day long, what's going to happen? Okay, so Melissa, we do have a question from a name I recognize. Hi, Teresa. When you say that they're able to, what do you mean? Physically sign it or understand what they're signing?
Yeah, it's actually a really good question. And I apologize for not being more clear earlier, but they have to be able to understand what they're signing. So I tell clients this all the time. The number one indicator that someone is not actually having the mental capacity to sign a document is when someone tells me they will sign anything I put in front of them. Because then they are physically signing. They don't necessarily understand what they're signing. So it's important that they have the ability to understand, and this is realistically what we're talking about with powers of attorney. They have the ability to understand, I am giving authority to this person to access my information and manage things on my behalf. Whether it's a financial power of attorney that you can do right away, or a medical power of attorney that you're going to do when you're not able to make decisions for yourself. But it's about the mental capacity, not the physical ability to sign. If someone's physically unable to sign, which does happen, people don't think about this a lot, but someone can have mental capacity, but physically not be able to sign something. The law already prepares for that. So there are situations where that definitely happens. I mean, we have it happen with older clients many times. You think about someone who has Parkinson's or something like that, they physically cannot sign, but they understand what they are doing. There are rules in place where notaries can sign on their behalf. So that's actually not even an issue. It's about mental capacity.
So Melissa, that brings kind of a question to my mind, and one that I've heard. Can you talk to us a little bit about that paradox that if your child cannot mentally understand the concept, wouldn't you need guardianship over them even more? And then what do you do?
Yeah. So if they don't understand, that's the thing. If they don't have the ability to understand the concepts of, I need this person to help me and I'm giving them control, you are going to need a guardianship, because they don't have the ability, legally speaking, to sign those documents. Now, have I run into scenarios where people have gotten by with powers of attorney that they've pulled off? There's always scenarios. I can't recommend that, because someone at some point in time is going to question that, and it's going to come back to bite you if that happens. So if you have a situation where there realistically is not an ability for your child to understand what they're signing, then you shouldn't be going that route, and you should be going down the guardianship road. Because the other part of that is, you want to think about this. If you have power of attorney for someone and you've said they have the ability to sign that document and make decisions for themselves, if something happens to your child, you've basically already said they have capacity to make that decision. So if someone manipulates your child, if someone gets into a situation where your 18-year-old does something that they wouldn't otherwise do because they don't really have the ability to make those decisions, having signed that paperwork can come back to bite you. You really want to have that guardianship in place so that you can protect your kid.
Okay.
Because that's a lot of it. There are always those scenarios where, I've run into it a lot with our clients where, you have a child, take, for example, Down syndrome. If I have a child with Down syndrome and, my child is sweet as can be and is going to do whatever someone tells them to do, and I have that child sign a power of attorney, but then a couple of years go by and the wrong crowd gets involved, and now my child just committed a crime or did something with those people, maybe not be it a crime, you're just opening up the door for liability that you don't want to have on your child. If you have the guardianship in place, you're saying they don't have the ability to make these decisions, and it can be really protective for your child in the worst case scenarios. And that is a worst case scenario,
So
but
they,
it's really
they don't
important.
have to have the capacity to understand when they have the guardianship.
Right, because when you have the guardianship, you are saying they don't.
Okay.
That's why you have the guardianship.
If you can go to the next slide, I will wrap up. We'll keep it on my last slide while you answer the rest of these questions that are coming up. We do have a link here to all of our upcoming webinars, so you'll be able to check those out and see what topics are slated to come up next. The next slide, this is our team. We are, like I said, we're located just outside of Houston. We're an independent firm. We have 4 advisors, 2 husband and wife teams. That's my husband with the beard there. And then we have girls who help out with the office daily things, paperwork, marketing, all of that. And then our last slide is how you can get in touch with us and sign up for your free consultation. So we give everybody a free initial consultation. We answer as many of your questions about special needs planning as we can. We learn about you and your family, and then we're going to tell you how we work, what we charge, and we can decide together if it would be good for us to move forward in a working relationship. Now, those sweet girls, those pictures that you saw earlier, they're going to be calling you because when you registered for this webinar, you did give us your phone and email. So they're going to call and say, hey, do you have any further questions or would you like to set up an appointment? So please don't hang up on them. We understand the word no perfectly well. We're just doing our jobs. If you don't want us to call you, call us first. Tell us whether or not you'd like to schedule an appointment. You can use the QR code to go straight to our calendar. You can call us or email us, contact@cpgcares.net. And of course, we've included links to our YouTube channel, our Instagram, our podcast, and our Facebook channel. So let's leave this up while we take on these last few questions, Melissa, if you don't mind. What happens when you designate the state to be the legal guardian?
So this is going to be a little bit of a non-answer to your question because you would never designate the state to be the legal guardian of your child. If, let's say, you failed to name a guardian for your child, so whether it was that you have minor children, someone passed away, didn't have a declaration of guardian, or you have an incapacitated adult child that you were guardian over and didn't do the same, what's going to happen is that someone close to your child is going to have to step forward to obtain guardianship over them. Now, if you had guardianship to begin with, meaning your child was over 18, you've obtained guardianship over them, and then something happens to you and you didn't have a declaration of guardian where you designated a friend or family member that you trust in that role, then the court is going to be made aware of your passing and they're going to seek out a guardian. Now, generally speaking, there's a hierarchy. And do they have access to the slides after this presentation?
Yes, we're
Okay.
going to email all the slides to them later on today.
Perfect. So in one of the slides earlier in the presentation, they're listed there, the hierarchy of what the guardianship hierarchy is. And it's always going to be, essentially the easiest way to explain it is next of kin. So we go down the family lineup. So if there's another parent alive, that would be the first in line to be the next in line guardian. Siblings, if they're adult siblings. If someone's married, of course, their spouse would be in that lineup of things. But it's going to be appointed to someone who is close to your child. Now, if there's no family member or friend, that's when the court is going to seek out an organization or another professional to act in that role. If it's a guardian of the person, it's generally going to be an organization like a care management organization or something to that effect. If it's a guardian of the estate, it's generally going to be an attorney that they appoint. And then just to be realistic, if there is an estate, your child's estate is paying a lot of money to a professional to act as their guardian on top of everything else. So really important that you have those declarations of guardian in place so that you can name people you want. And generally speaking, if you do that, the court's going to abide by your wishes as much as they possibly can. So long as the people that you choose are not disqualified from serving, they're going to go with your wishes.
And does guardianship make me responsible for actions or lawsuits against my child?
So generally speaking, being someone's guardian does not make you liable to third parties for the actions of the ward. I will use that term in that situation. But there can always be exceptions to the rule. Now, what could happen is if something happened that the person under guardianship had done something, and it could come back to you having been negligent in your authority over them, that's different. Then you're technically liable to the individual, not necessarily the third party. So you still want to be careful and keep, because that's your job. Just like parents, it's your job to be a parent to your child. When you get guardianship over the age of 18, you are supposed to be keeping an eye on them and making sure that they're safe. That's really all it comes down to.
All right, well, that is the last question that I see. So if you have another question, please throw it into the chat box as we're wrapping up and we'll grab it. I want to thank you so much, Melissa, for again sharing your knowledge with us, being here with us today. It's always so nice to see you, and you do such a great job with the presentation, sharing your information. And Natalie, for hosting us today and for sharing us with your families and letting them know that we're out here. We truly appreciate you. And finally, to everybody who stuck with us today and attended, we know that your time is valuable. Again, if you would like to watch this webinar or check out any of the others that we've already done, they're on our YouTube channel. You will receive this one and the slides later on today in your email. And if you have any questions, please feel free to reach out to any of us. We're here to help. Like I said earlier, that's what's in our hearts, not just our jobs. So feel free to reach out to us. Thank you again. I hope you have a great weekend and take care.
Thank you.
Thank you guys so much.
Thank you.